Hello and welcome. It's Anas in contempt of court, and probably we have to extend it. It's the whole Ghana in contempt of court, because that's what's happening. Well, some of the judges who have been allegedly, misbehaving themselves in Anas's video, the lawyer representing them has, gone to court to say that Anas is in contempt, the premise is in contempt. Indeed, everybody who went to watch the video is now in contempt. I hear some television stations have been roped into it. So we're going to move this conversation forward to find out from some legal brains and indeed my brother, what is really happening and what should they do? Should they keep quiet and hope that this matter dies away, or get up and fight, because indeed the law says they are innocent until proven guilty, and indeed until a court of a competent jurisdiction says so. Whether what you and I have seen or heard, they are still innocent. What would you rather they do? Just keep quiet and let this matter die, or get up and fight because maybe they believe they are innocent? And that's what we are talking about. With me in the studio is Malik Dabo, my analytic brother from My Joy Online editor. And then joining us on the phone will be Professor Michael Quay, who would also share his thoughts, because he's actually told the judges, look, you just keep quiet, probably even be very remorseful or apologize and hope this matter dies away. But I'll come to studio and start with my brother. My name is Nana Sakwa. This is PM Express. And Malik, thank you very much.
Thank you, Nana.
Malik, this case, and I think this is the third day running we are talking about this, and yes, we have to devote airtime to it because this is a democracy shaker. But let's look at today's incidents. I mean, every day turns a new corner. Everybody seems to be in contempt of court now. What is happening? I mean, number one, let me start with Anas. Is Anas in contempt?
Well, whether Anas is in contempt or not is not for us to determine. It's for a court of law to determine whether he's in contempt or not. So that's first. It's important to stress that regardless of whatever we are going to say here, whatever Justice Derry and the other judges are doing or not doing is within their legal right to do so. There's a legal maxim that says that a person is presumed innocent until proven guilty. So we cannot say that on the basis of what we have seen in these audiovisual recordings, there's prima facie evidence that the persons named as having committed several acts of impropriety and corruption and bribery are guilty for that matter. So whatever Justice Derry and his lawyer and the others are doing is within their right to do so. If somebody were to make an allegation against you or me, we will be required to go to court and to seek to enforce our rights and to challenge whatever claims anybody is making against us. So it's important to stress the fact that they are not violating any rule by doing the things that they are doing. Now back to your question whether Anas is in contempt. We have to look at what basically is in contempt. Contempt primarily is meant to ensure that people do not act in a manner that scandalizes the court. That's basically what contempt is, that you have acted in a manner that seeks to hold the court of law in contempt. That is, you are acting in a manner that shows that you have no regard for the court of law and that you are being disrespectful and you are scandalizing the court. It is when you do these things that one can be said to be in contempt. What Justice Derry is doing is, we do know that yesterday Justice Derry was in court together with his lawyer, and they filed an application for interlocutory injunction on the Accra International Conference Center. And when we say interlocutory injunction, you are saying that there's a matter which is pending in court. You don't want that matter to be touched until all the issues are resolved. For example, if somebody were to appear from nowhere and argue that this building belongs to him or his dad, and that it was bequeathed him by his dad, he has legal right and legal title to this land. Meanwhile, we did not lease this land from him. We took the land from somebody else who claimed to have title or proprietary rights to the land. Now, the land has become a subject of litigation. If we go to court or if this guy goes to bring a bulldozer to come and pull down this building because he alleges or claims that he has legal right to the land, what we can do is to go to court and seek an interlocutory injunction. Before we do that, we would have gone to court to challenge his claims. But before the court will go into that matter, we have to stop him from pulling down the building. In that case, we'll go to court ex parte. Ex parte means we go alone. We do not go with him. We go to court and tell the judge, look, we have this building elsewhere. We have invested in it. This guy comes and he's making claims that he owns the land.
So let's stop
this matter is in court.
Matter.
Let's stop him from destroying the property before the matter is gone into. Otherwise, if he's not stopped and we go into the matter, it turns out that his allegations and claims were frivolous and bogus, and that we leased the land or we obtained the land from somebody who had legal rights to it. This guy would have pulled the land, he would have pulled the property down. That's the purpose of interlocutory injunction. His claim was, we are contesting the legality of this video that Anas is going to screen. But before we even hear that, we must stop Anas from screening the video. Is the reason they went to court yesterday and filed that interlocutory injunction to try and stop the conference center from allowing Anas to screen it. They served those processes on the International Conference Center, and yet the screening went on. He went to court today to say, by going ahead to allow Anas to screen this video, the International Conference Center has held the court in contempt. They have acted in a manner that shows they have no respect for this court, and that the conduct scandalizes the court. Let
me bring in Professor Mike Okoye. Prof, thank you very much for joining us.
Yeah.
Prof, I mean, is it not fair that the movie would have been, judging from what my brother Malik was saying, wouldn't it have been just fair to, hold on for, if indeed we are challenging what the content of the video, well, hold on, let's have a look at what's in there before you go ahead. Is it a fair, argument if I ask you?
Thank you very much. In looking at cases of this nature, there are a number of factors that the court would like to consider. In a particular case, it was said that an application for injunction is not an injunction. An application for injunction is not an injunction. It depends on the subject matter, the nature of this case, the circumstances of the case, the motive for the application, what needs possibly to be preserved. And the example that was given, for example, right now, deals with preservation. A court will normally not condone a thing being destroyed before even it has heard the case. Otherwise, it will be an exercise in futility. It's very important to see this. Will it be an exercise in futility? And this is not. This is a typical matter that borders on criminality. And where that is concerned, civil matters could be distinguished. Let me give you an example.
Yeah.
Manshia Palace belongs to Asante. It is a notorious fact. Then I, an Osu man, bring a summons some days before the great king holds a big function over there. Then I say, look, I'm seeking a perpetual injunction because that property belongs to me. In the meantime, I'm in court on Thursday. Give me an interim ex parte injunction so that I'll stop him from holding his function in effect on Saturday. You see how an application for interim injunction can be used as an instrument of mischief, which the court will not countenance. So, in other words, the nature of this case, the prima facie issues involved, will all be totally taken into account, including motive. It's the motive is such that it flies against public policy by way of something that should be known to the public.
Prof, let me, sorry to cut you in there. With regards to destruction, I mean, could they say that their image will be destroyed and therefore hold on so that we can rectify? Because once he goes out, whether I'm guilty or not, if my name is out there, I'm finished. Image, I'm destroyed.
Now, well, this is what I'm saying. It all depends on the totality of the facts. And that's why I'm also making reference to the fact that an application for an injunction is not an injunction. Because in the example I've given you, I mean, just off the cuff, for example, you cannot use this to stop the great thief from holding his function. Nobody would tolerate that.
Okay.
Otherwise, an injunction too can be used to suppress the truth. And if the extent of it will be to suppress the truth, to suppress facts that must come to the public purview, to even, let's say, hide a crime or prevent a crime from being coming to public knowledge, then of course a different issue will apply. So in the meantime, if anybody wants to apply for an injunction, let him do so. If anybody also believes that this will not hold, that person can also go on, because you have not served him actually at this stage with any injunction. That's why I say we must be very, very careful, because there's a thin line here. An application for injunction is not tantamount to an injunction having been granted by a court of competent. Otherwise, such interim ex parte applications, while they are merely pending, can be used as an instrument of mischief.
With regards to the premises that we're going to show the movie, I know that was withdrawn, but there was also an injunction on the premise to say, look, you're not allowed to show this thing. And they went ahead to show. Where do they stand legally with regards to that?
This is why I'm giving you, how do you look at the facts of a peculiar case? An injunction is a discretionary remedy, as the courts repeatedly say. It is a discretionary remedy. If a court gets the inkling that granting an application will essentially amount to suppressing some truth by way of letting a person who has done some wrong get away with something, the court may not countenance it. So I say it depends on the facts, the clear facts of the case, the clear circumstances of the case, the nature of the case, the subject matter involved, the motive for the application. All these will go together in order for the court to consider it. But if the court will say, this is essentially an application to suppress truth, the court can dismiss that. And so a person can test it and say, look, this will be essentially an application to suppress truth. And truth, on upholding the truth, is the fundamental duty of the court. Therefore, such application will not stand the test of a court process. The person is entitled to also say, so I'm not going to bow or be cowed down until a court of competent jurisdiction actually issues an injunction. That is why I say, essentially, an application for injunction is not an injunction.
Prof, you also on record on advising the judges or who are alleged to have done something or who appear in the video to take more the quiet side and show a remorseful front, even maybe apologize and hope that we forgive them. I mean, do you still stand by that?
Oh, definitely. And that one is, you see, at this stage, somebody knows in his mind and his heart, did I take or did I not take? And so if you did, that is with an if. You will not have shown remorse. And it may make your punishment bigger at a subsequent occasion. This is a fact in criminal penalties. If a person shows remorse, you treat him a bit differently for the person who does not show remorse. even though the same offense may have been committed. So it can be a general advice, because remorse showing is a factor taken into account in sentencing. Very, very important.
At the moment, Justice Derry has gone to the Supreme Court to try and set aside Anas's petition. I mean, how much of a case has he got? Because everybody keeps saying that the method of gathering this evidence, is a bit fishy and maybe may not hold in court. How would it work at the Supreme Court?
If you talk about the methodology, you ask yourself, even by your own code of conduct that was got from the Evidence Act of Ghana, normally you will not gather evidence and be allowed by subterfuge. But then it goes on, as you see in 2, that in exceptional circumstances and in the national interest, the public interest. And that's why I say public interest overrides everything. And that is why in the famous Chicago case that I gave you, that famous Chicago case, Operation Greylord, despite all the subterfuges and assays of bias that were used, which would normally not be used, the importance of justice being corrupted overrode everything according to the Chicago Supreme Court, and which was upheld in the U.S. Supreme Court. And if you read that case, you will see that it's as if Anas went and copied it. And in public interest, because justice is the most important matter on earth. If our justice system breaks down, we shall be going back to the jungle. Everybody can take a cutlass and go anywhere. Anybody can commit armed robbery and get away with it. Anybody can go and rape anybody's daughter and get away with it. Can you imagine what kind of brutish society we're living in? And that is why the U.S. Supreme Court said, look, the overriding interest of America surpasses all. The most important thing we now want to see is the evidence. Did you do or did you not do? I believe that it will come to that.
At the moment, Anas is on, has immunity. I mean, can they relook and take his immunity and then try him in court? Because otherwise, everything is futile.
Well, and this is the interesting test in this particular case, my brother. Anas has done it with regard to so many other institutions. The state appreciated him so much that immunity was granted to him. And in fact, it is a national approval of his methods. He was not killing anybody. He was not injecting anybody with chemicals. He was merely using exclusive detection equipment in order to bring and fish out criminals. That's all. So you realize that in the final analysis, that immunity which was given to him, which was approved by everybody, that immunity by regarding which, whether it was SEPS or so many other institutions, he brought out things that were wrong, and we all applauded it, including judges. Now he has reached judges, then we can cry foul. That's why it won't work. So it was because of the overriding public interest that he was even giving immunity. He holds the immunity in his pocket. And the immunity will apply. Not only that, by law itself, the overriding public interest seen in the evidence law of Ghana, approved, as you know, by your Journalists Association, the rule which tells every judge, which is their fundamental rule, the Chief Justice mentioned it just about some 2 weeks ago, that you cannot even discuss a case before you with another person. If you discuss, if you bargain, if you are giving and you take, these are matters of, terrible facts which touch and concern the public interest, which would override all other things. And that is what is the quintessence of this matter. And it has happened before. I quoted from the Indian cases. I quoted from British law. I quoted from America. And these are common law countries whose law is akin to ours. And you cannot stand it.
Prof, I'm going to take a break here. I'll come back to you. With regards to this is literally a conveyor belt of, judicial service personnel who are in trouble. This must be, classic. It's not as if there's one or two, but a whole lot of them. Will this make this case peculiar? Let me take a break, and then when I come back, you help me out on this.
Thank you.
You're welcome. Well, thank you very much for staying. Is Anas in contempt of court? And I think, Prof. Okoye said something which has been my fears from the beginning, that without a judiciary, you have a state of anarchy and everybody can go out doing the same thing, especially if they know that, listen, you look wealthier than me, and if we get into court, you will pay your way out, then let me have my justice now before we go into court. But before I even bring Mike Okoye in, let me come back to studio and find out from Malik. Malik, so at the moment, who are in contempt? I mean, who are they filing?
Well, because this application was against the International Conference Center, they are citing the manager of the conference center, Kofi Appiah, and then UTV. Our information is that UTV screened the video as it was being screened. The UTV showed it to its viewers. So it's a reason they are citing UTV as well. So they're citing UTV and then Kofi Appiah he is the manager of the conference center. So those are the people. But I just wanted to make one quick point about, Prof spoke eloquently about how to distinguish the cases when they come before a court. And he makes the case that, look, this is a discretionary power that is given to judges to determine whether there is a case to answer. Because, first of all, you are saying that the conduct of these persons scandalizes the court. It lies within the court to determine whether it is true that the conduct of the people scandalizes the court. Now, let's look at this specific case. International Conference Center entered into a contract with Tiger PI to screen this thing. This was done a couple of weeks ago. At the time that they entered the contract, there was a binding contract between Tiger PI and the conference center. Tiger PI would have become a licensee. A licensee simply means you have a house, I come to your house, and I pay you rent. You give the house to me. What I use the house for, it's not for you to determine. In fact, I can keep you away from that house. If you come to that house, I can ask you not to come in. Because once I have paid my rent to you, I become a licensee. Within the period that the contract subsists, I reserve the right to use the property for whatever purposes I want to use it for, lawful purposes. One could argue that Tiger PI obtained a license from managers of the conference center to use the facility. And they had booked the facility for a number of days. So they were licensee. After they have become licensee, the managers of the conference center reserve a right to determine whether Anas uses the place or not. That's difficult to tell. And that will be a bar that Justice Derry and his lawyer have to cross if they have to make out this their contempt case against Kofi Appiah and UTV.
But let me come back to you, Professor Okoye. But before we're going on a break, I wanted to find out that this looks, with the numbers involved, does it make it, landmark case, a unique case, and therefore maybe you wouldn't have a lot of examples around the world to compare that, maybe in England there were 40 judges who were caught, or in America there were 100 judges who were caught. So will this make it different, Professor Okoye?
You know what? What the young man has said is very, very correct and interesting. Let me add one thing which will help us to appreciate this issue. There's a fundamental principle of law. Ex stupid cosa non actio oritur. It says that out of an unlawful act, no legal action can arise. It is a fundamental issue. So the moment a person says, you yourself, you have been engaged in illegality, on the faith of the judge, going to rule on this matter, what were you doing having people in front of you as a judge who had no business coming to discuss a case before you with you, which is one of the fundamental laws of being a judge? The Chief Justice referred to it presently. You can't answer that question. And also, what is it that we primarily see as footages of what you were receiving? I will not grant an injunction. If you have a full case to come and present your full case, I will listen. These are the principles of injunction. So if somebody says that, look, this man is issuing an injunction, claiming that Osumanche Palace and its grounds are his property, the man can treat you with contempt and say, what are you talking about? You must be dreaming. I'm not going to stop holding my festival because somebody comes to file that's a frivolous application. This is why I want us to always note that an application for injunction is not an injunction. I did one case like that by way of some people having brought a whole board of directors of the CDH to court over this. And we won. Because an application for injunction cannot be used frivolously, and people think wrongly that once you file an injunction, then you can waive it. Otherwise, it can be used also for mischief. And in determining a prima facie case, matters like a stupid causa non actio oritur will all arise. And if the person shows by some basic evidence that, look, there is illegality on the part of the man who is before you. My Lord, there's illegality on the part of the man who is before you. He has even broken the fundamental law for judges. He will get the injunction. So the judge should say, now, come and present your full case. As for injunction, we are not going to waste anybody's time over it. And of course, it is true that there's a contractual obligation on the part of those people who look after the conference center. And until there is something really binding, like a court order fully, not just some application in front of them, they have to go on. Otherwise, they themselves will be in breach of contract. These are the relevant issues in the law.
Going back to my question with regards to the nature of this case, there are quite a number of judges who have been implicated and a whole lot of judicial service. It makes it a landmark case. Is there anywhere that you can pick and point and say, well, it's been happening here before? I mean, it's like the first.
Yeah, and you know what? It is a test. And Ghana will better pass it. And that's why I refer to the famous Chicago matter, Operation Greylord. It went deep. Court clerks, judges, and other intermediaries, middlemen. There are middlemen in this business. They were all roped in. And they were jailed. 5 years, 10 years, 15 years, and so on. They were even struck off the list of lawyers and prevented from practicing. So there are times when, this is the thing about democracy and good governance. The developed nations have a way of cleaning their system when they see something going wrong. If you try not to let the system be cleaned, I tell you, there will be a violent cleaning. In 1982, I was practicing in the High Court when revolutionaries invaded the court. It was no joke. You could feel the real hit that justice emanates from the people, like we have said in our 1992 Constitution. I ran, left my car behind, down to the Mokala, that lane there, with my coat hanging on my shoulders, and got home. So you see, the way that Americans, the Indians, have quoted the famous Chief Justice of India, that are often referred to in British courts. I've quoted these things. So if we also want to develop and have the peace and stability of India, a very stable, well-developed democracy, we should quickly clean the stable by constitutional and legal means, and not wait until the people get tired of justice and then be tempted to take the law into their own hands.
Prof, let me take you back to my concerns, which you've raised it a couple of times in your statements, as in the sensitive nature and the dire nature of the judiciary. My concern was that should the Judicial Council have looked through this tape, cleaned up the mess before informing the public, or should we inform the public and then get back to work?
It can be contemporaneous. It can move simultaneously. One is not, the two are not mutually exclusive. And you see, whatever will happen belongs to the people of Ghana. It's the people of Ghana who are watching. They are entitled to know. In fact, then they can also make up their minds whether what the Judicial Council or whoever is saying is correct or not. So as for facts, like you journalists say, facts are sacred. Comment is free. Facts are sacred. Let the facts come out. What interpretation you put on it, what legal arguments we want to say, whether even by doing that it is legal, let the lawyers say. But nobody can or should try to prevent the people of Ghana from having access to mere facts. Nobody can do that. Not in this day and age, where whistleblowers by law are entitled to compensation and entitled to money being given to them. We are in the world of transparency. We are in the world of information and knowledge through information. And when you have this kind of world, you cannot prevent people from being told mere facts. As to the legal interpretation, as to what the facts mean, as to the connotations of those facts, it's a different matter. But I tell you, the good people of Ghana, like the good people of Chicago and other places, are entitled to be exposed to the truth.
Prof, hold on for me. Let Malik take us to the Supreme Court and find out what's the demand that they want from the Supreme Court. What's the petition in the Supreme Court?
Well, Justice Derry is essentially asking for 10 declarations. He wants a declaration that the first defendant, and there are 3 defendants here. Tiger P.I., the Chief Justice, the Attorney General. Tiger P.I. is the first defendant. He wants a declaration that Tiger P.I.'s publication of the petition to the President in the media contravened Article 1468 of the 1992 Constitution. I'm sure as we discuss, we will explain what Article 1468 means, what the constitutional provision says. This provision simply says that whenever there are disciplinary proceedings instituted against a high court judge or a judge of the superior court, the hearing should be held in camera. We all know this. Now, his contention is that by screening this video and by publications in the media, on Anas's own Facebook page, on the New Crusading Guide newspaper, where Anas is acting editor-in-chief, he says that Anas' conduct, i.e. that is these publications, are in violation of Article 1468 of the 1992 Constitution and therefore unconstitutional. He wants also a declaration that the conduct of Tiger P.I., acting through its chief executive officer and editor-in-chief of the New Crusading Guide, Anas Aremeyaw Anas, in releasing the contents of the petition through publications in the New Crusading Guide, his personal Facebook page, public screening of the audiovisual recordings in support of the petition at the Accra International Conference Center on the 22nd of September 2015, containing the evidence in support of the petition, is in violation of Article 1468 of the 1992 Constitution. He went on and he says that the Judicial Council's statement that was issued, written by signed by the Judicial Secretary, was also in violation of this same section of the Constitution, Article 1468. because his argument is if the Constitution requires that these hearings should be done in camera, why would the Chief Justice, acting through the Judicial Secretary, put out a press statement naming him, Justice Derry, as one of the 12 judges who have been caught on these audiovisual recordings allegedly taking bribes? So yes, it's one of the things that they are seeking. So he wants the Supreme Court to declare that as also a violation of Article 146A.
Okay, let me take a break here. When I come back, I think Prof will help us at breaking down this Article 1468 because it seems to be appearing everywhere. So we'll just take a quick break and come back. Well, thank you very much for staying. Is Anas in contempt of court? Indeed, it's the whole Ghana in contempt of court, and that's what we are looking at. I come back to the studio. Actually, before then, let's take a short video and see what the general public think about what's going on.
Okay, so can you give us your name?
David Andrew.
Okay. So, David, are you shocked by what you saw inside?
Yes, I am.
One word to describe what you saw inside.
Disappointing. It is. I think it's a terrible indictment. This is a strong arm of government, and it shouldn't be brought down like this.
But, yeah, so are you also, many are saying that they've lost confidence in the judicial system. How about you? What would you say about the current judicial system?
I think the evidence is pretty clear. It wouldn't be a matter of opinion anymore. Any objective observer would notice that this is really bad. It's terrible.
So how best do you think we can restore the confidence back in the system?
I'm not sure how this is going to start, but it's going to be a big task. Frankly, it's worrying. It's very worrying. I think if new structures are put in place so that there's proper checks and balances as far as judges are concerned, so they would actually come up with proper reasons for how they reached some of their decisions, it probably would help. If this is probably a microcosm of the Ghanaian system right now, which is pretty rotten. But then it has to start from the education system. People need to be properly educated. Drivers should understand the rules on the road. There's so many things that have to start from basics, and it has to start yesterday. We're well past the time now. A lot has to be done quickly.
One word to describe what you saw in there.
This is disheartening. Disheartening. You cannot just imagine what is happening in this country. A moment as I was watching that, and I asked myself some few questions. Who watches over the watchman? We are talking about corruption in this country. What the final destination of corruption is our law courts. And these are people who should really
be upholding the law.
Uphold the law, look through the law and tell the truth. So if this is where our country has reached, my brother, I wonder where we've got into. The country really need real pegging. We need to peg everything in this country. Because if the final destination is what is happening, where we are now, hey, my sister, is disheartening.
From the way you're speaking, it looks like you've lost some kind of confidence in the system.
Madam, there are some of the judges, I know them very well. I have one way or two had an interaction with them, and at least expected them to be doing what they did. What they did, to me, is more poisonous than the word poison. How can you be doing this? You know very well. For instance, there is a case in connection with a widow whose land was being taken away from her, and her case was pending before a judge. You took a bribe and you ruled against her. How can it be? Where are we heading towards?
So how do you think we can clean the system? Where do we start from?
Look, we need a real orientation, moral.
Disheartening, dejected, people have just given up hope. The very thing that I was so scared when this video is coming up, everybody says, oh, Nana Sakwa, probably his uncle is one of the judges. No, I don't know any of the judges. But that fear that we finally give up on the judiciary, because then you just sign and seal a state of anarchy. But Article 1468 keeps coming back, and probably we need to make a song about it. Malik, what's Article 1468?
Well, as I was explaining, Article 146, first of all, Article 1463 says that if you have a problem with a superior court judge, you send a petition to the president stating the grounds upon which you want the person removed from the bench. The grounds must be stated grounds of misconduct or misconduct in the person's duties. Then 1468 says that when you make this complaint, when you send this petition to the president forwards it back to the Chief Justice, and the Chief Justice has to look into the matter and establish prima facie case. And I was explaining, prima facie simply means on the face of the facts, the person has a case to answer. That's prima facie. And that's where we are at this point. These 12 High Court judges, what the Chief Justice is doing after the president forwarded Anas's petition to her is to establish prima facie evidence against them, to say, okay, we just look at the facts. On the face of the facts, we think that you have a case to answer. Then they can go into the processes to remove them. The Constitution in 1468 says, when you start these proceedings that will culminate in a judge being impeached, the hearings must be done in camera. In camera simply means it must be done away from the public's eye. That's in secret. That's what the provision says. And Justice Derry is contending this provision has been flagrantly violated by both the Chief Justice and Tiger IPI and all the persons involved in this matter. So he wants a declaration that all the measures instituted, first of all, that the petition filed by Anas is null and void and of no effect, because he says if you file a petition and you go and make the contents available to the public, you violate this constitution. And to the extent that you have violated this constitution, the petition should be declared null and void. And he wants whatever processes that the Chief Justice has initiated, the Supreme Court should declare same as also null and void.
Do you think they'll get that?
That's not for me to determine. It's for the court to listen to their argument and to determine whether there is merit. I'm sure when Prof speaks to us, he is better placed to give us further education on this matter. But after he has he's made submissions, I will read a case, portions of submissions, or portions of a judgment of Justice Dateba when a case of a similar nature came before the Supreme Court in Ejechum and Attorney General.
Have I still got Prof on the line? Production, have I still got Prof?
Yes, you've got me.
Oh, good. Prof, we've just heard from Malik, who's, tried to explain this article in the Constitution. I mean, so clearly they have a case. I mean, the Supreme Court has no choice but to grant them and, probably strike the case out.
These are what often makes cases interesting, distinguishing the facts. You see, at this juncture, so far as the investigation that has been published is concerned, it's a mere presentation of mere facts by somebody for public consumption. The public interest is that one is entitled to know. The process is not, therefore, at this stage meant to be veiled in secrecy, because the public must also understand the ultimate outcome, and they can only understand the ultimate outcome if they also have a good inkling of the matter. Then we are told, at another stage in the process, when the Chief Justice, having examined things, having got the president, and a prima facie case having been established, then there will be proceedings. Those proceedings are a separate matter. And in fact, the documents on that, upon which the proceedings will be held, will not be published. It will not be made public. That one is for the purposes of the inquiry, which the Constitution says must be held in camera. So you must distinguish the two stages. This is purely journalistic. This is purely a matter of public interest. The next stage may determine that even there's no prima facie, so this case must move further. How can the public also be part of the understanding process? And that is why I say in this day and age, we don't hide things from the public. And a person must know that when you hold public office, your activities are open to public view. What will become the matter of the prima facie case having been determined and you're being tried, sort of, in camera, is a different matter altogether.
Prof, hold on for me. Yeah, we got, there's a ruling by Justice Dateba, right?
Yes. What Justice Derry and his lawyers are relying on, in addition to the sections of the Constitution we just spoke to, is a case that was decided by the Supreme Court itself. Lawyer Bright Akwete, we all know him, brought a case to this. He filed a petition to the President seeking to remove from the bench the Chief Justice at the time, Justice George Kisliakwa. And he stated grounds upon which he wanted the Chief Justice removed from the bench. Now, when he filed a petition to the President at the time, someone leaked the petition to the media. After the petition was leaked, one Ajechum went to the Supreme Court and brought an action against the Attorney General, asking for interpretation of the constitutional provision 1468. His case was, once Bright Akwete's petition was leaked to the press or to the media, his contention was that it was in violation of Article 1468, and to that extent, the petition ought to be thrown away. The Supreme Court, by unanimous decision, upheld his argument and declared the petition filed by Bright Akwete null and void. I want us to look at just a portion of Justice Dateba's ruling on this matter. This is what he says. The constitutional requirement that the impeachment proceedings be held in camera would be defeated if the petitioner were allowed to publish his or her petition to anyone other than the President. This is likely to lead to the petitioner's allegations being aired in public, while the judge's response can only be considered in private. This would lead to grave adverse public relations consequence for the judiciary. The institution of the judiciary could be undermined without any justification. Accordingly, in my view, a petitioner under Article 146 may not disclose the content of his or her petition to the media, nor indeed to any person other than the President.
I'll take a quick break here and then we have to don't move. And this is an interesting and a landmark case that will be studied worldwide. I'll come to the studio. Let me talk to Malik, my brother. Bruv, I mean, so then what then happens to the Supreme Court? They've already ruled to say, well, there is a case, you've leaked it to the press, therefore you have no case. Now another one is coming, which is quite similar, which is also being leaked to the press, and as we speak, there are people rushing to actually go and watch it. I mean, this is not being leaked. This is actually being shown and advertised in the press. Where does the Supreme Court stand?
Well, Prof was talking about distinguishing cases. Normally when a case comes to court, what the court does is to look at the peculiar facts of each case and distinguish the cases. You may have a case in which the facts are similar, but then the court will still look at the case and distinguish them and say, well, the facts may be similar, but in this case, there is a certain change or a certain difference, and to that extent, we will hold or we will rule in a manner that is different from the previous case, the way we ruled. I think that in this case, the Supreme Court may come to a conclusion that there's a certain distinguishing feature here. In Ejechum, an Attorney General, Brett Equity was not a journalist. In this case, Anas is a journalist. Anas, as a journalist, has an obligation to make public whatever he has found out. Remember that justice emanates from the people.
But not if he's trying to remove a high court judge. Then,
Nana, at this point, there is no evidence that what Anas has put before the president, on the basis of which he's founding a claim that these judges must be removed from the bench on stated grounds of misconduct, we do not know that it's the same evidence that he put out there in its entirety. We do know that he has 500 hours of video. What was watched yesterday and what is being watched today is only 3 hours. So the evidence as he attaches to the petition may not be the same evidence that he's put out there in the public domain. Of course, there may be some overlapping evidence, but it may not be the same evidence. To that extent, the court can distinguish from the previous case. It is also important for us to remember that when you look at the structure of the courts, the Supreme Court, which has supervisory jurisdiction over all the other courts, can't depart from its own rulings. It is not bound by its ruling. If this case had been filed at the High Court, the High Court would have been bound by the decision that the Supreme Court took in Chum and Attorney General. But the Supreme Court is allowed to depart from its own ruling. If the Supreme Court looks back at its own rulings, it can say, look, we erred in this matter, or upon some new information available to us, we think that that case was wrongly decided, or we can decide it in a manner that distinguishes it from the previous case. Remember Martin Amidu went to Supreme Court with a case. When the court decided, he went back and appealed to the same Supreme Court. The Supreme Court held differently from the previous case, which means that the court can't depart from its own ruling. It is not bound at all.
I'm sure this conversation will still go on, and indeed it has to go on, and we need to sensitize the public, because whatever happens, we cannot afford to lose faith in our judiciary. There are still good ones in there, and they will make things right. On Thursday, that's my opinion, Joy FM. Now, tomorrow being Eid for our Muslim brothers, and I'm looking forward to some rice and stew from any Muslim, all my Muslim friends, do forget me not. But the topic tomorrow is not all Muslims are terrorists, but most terrorists claim to be Muslims. Not all Muslims are terrorists, but most terrorists claim to be Muslims. Very good, sensitive topic that we need to talk about it. Malik, thank you very much. Tomorrow we'll be back to do this all over again, but Tantis, who makes my shirt, is on 024-36-2001. Give them a call, get yourself a nice shirt. Thank you very much for watching.